This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Good afternoon, everyone. My name is Hayward Cho, and I'm the General Manager of ADR Services in Southern California. Thank you for joining us today on a program on Legends of the Law, Trial, Arbitration, and Mediation Tips from the Experts. Before we dive into our program today, I would like to go over a few housekeeping items. First, your MCLE certificates and handouts will be emailed to you by the end of this week. Second, this webinar is being recorded and will be available on our YouTube page should you miss any portion of the program or if you would like to share this webinar with your colleagues. Lastly, should you have any questions, please submit them in the Q&A function below. We will try our very best to get to your questions by the end of the webinar if we have time available. If we do not, I will forward the questions to the speakers so that they can answer them individually after the webinar. Now I have the pleasure of introducing our moderator, Stacie Hausner, who will then kick off our program. Stacie Hausner has mediated well over 500 cases in the areas of business, personal injury, real estate, employment, civil rights, and insurance coverage. She has been a full-time mediator with ADR Services for more than 5 years and has had an exceptionally high settlement rate. When Stacie is not mediating, she regularly teaches mediation and advanced mediation at Pepperdine School of Law and trains others through various programs and the Central District Court panel. So without further ado, Stacie, take us away.
All right, well, thank you, Hayward. I want to start by thanking you for joining us here today. To be honest, I'm pleasantly surprised and very appreciative to have so many of you with us. I think it really is a testament to the incredible careers and reputations of these panelists. Thank you, panelists, so much for sharing your lunch hour and for sharing your insights and perspectives regarding our professional field. Unfortunately, Debbie Chang couldn't make it at the last minute. She's in trial and there was a sick juror who changed the trial schedule. But we are very fortunate to have a legend in her own right, Mary Alexander, to take her place. So thank you, Mary. Each one of these attorneys has accomplished an incredible amount during their extensive legal careers. Each has received numerous legal awards, chaired many of the local and national legal organizations, and collectively they've tried well over 1,000 cases. They are all so humble that they've asked me to forego formal introductions, detailing their illustrious careers and countless accomplishments. That's probably a good thing because I think it would eat up much of the hour that we have here today. So let's jump right in and hear some legal advice from our expert panelists. I want to start by asking each panelist an opening question before engaging them in a roundtable discussion. So let's get started. And Bruce, if it's okay with you, let's start with you. Our question is, panelists, you have had an extensive legal career filled with lessons learned the hard way and others learned the easy way. What is the most important lesson that you have learned during your practice of law, and how did you learn it? All right, Bruce.
Sure. Well, there are many, obviously, but one that really comes to mind is when we come out of law school, we are covered with a bunch of armor, causes of action, rules of evidence, objections. I mean, we are just like armed to the teeth with all of these legal principles as lawyers. What I came to learn early on was when we are trying a case to a jury, that while we need to follow all those rules of evidence and be aware of all the elements of our causes of action, because on one level, we're trying the case to the judge to make sure we can get the case to the jury, what's really important is to be able to rip off all that armor when you're talking with the jury and be a person again. to try to find who you were before you became a law student and then a young lawyer, and find that, because the people you're talking to on the jury, they aren't all hung up on the concept of strict liability and tort and Greenman versus Yuba Power Products. They want to know the story of what happened in somebody's life and why some company should bear responsibility for it. And that is as much a human interest story as a legal analysis. So return to who you were, and that will increase your ability to communicate with the jury. So with all the stuff I've learned over the years about trying cases and being a lawyer, civility, all of those things, I think a major one was being a human being and not just being a lawyer. And then you'll be able to reach people that you might not have been able to reach otherwise. So that's my comment on a big thing I learned early on.
Thank you, Bruce. All right, Larry Feldman.
I
Are
think
you related?
I think I'm lucky to be related. I think that I've learned two things that I think is really important. First thing I learned was early on, in fact, from a lawyer that Buddy worked for, and that was Ned Good. And he once gave a lecture to, early on in my career, to Cala. And he said that if you don't like a case when it first comes into your office, reject that case. And that was really sage advice, because when clients come into your office, they tell you the best story they can tell you to get you to take their case. And they always leave things out. They always forget to tell you that when they come in and they complain about their neck hurting or something along those lines, that 6 months earlier they had another case where they made the same claim. Things like that, where in fact, it is true that even if they have the best memory, that they forget things to tell you in good faith, but it's always telling you the best they can tell you about their case. And I found the longer I practiced and the more I remembered that sage advice from Ned Good, the better selection in cases I made and the less disappointed I was when I found out facts that the clients didn't reveal. And I think the second thing that I've kind of figured out on my own that nobody really taught me. But for those of us who try jury trials, we live by the jury's instructions. And most judges are inclined to give the form jury instructions either from one source or another, but ones that are used over time and have been approved by the courts. So in trying to figure out how to structure a case, how to think about the case, and how to think about it in simple terms, like Bruce said, to communicate to the jury a real story, you got to have an idea what the judge is going to say. What is the judge going to tell them? What is he going or she going to tell them about negligence and how that's defined, or products liability, how that's defined? And if in fact you read those jury instructions at the beginning of your case, not when the client first comes in, not at the end of the case, but at the beginning, and you structure your case based on what the jury's going to be told and what you're going to argue in those jury instructions, you're going to find great success as a trial lawyer.
All right, thank you. Next, Mary Alexander.
Well, one of the things that I learned very early on in my career was to listen to war stories. And I know everybody says, I hate war stories, but I learned that they can be very helpful. And here's how I learned it. one of our senior partners at the firm had tried a case and was a brake that didn't work and caused the accident in the car. And he had his witness on the stand, and the expert said, oh, the brake was really bad and what was the matter with it. And cross-examination, the defense lawyer put a table in front of the witness stand and put a white piece of paper on it and said, would you come down and take the brake apart and show the jury what you mean? He says, well, I don't have any tools. I can't do it. The door to the courtroom opened and in came a cart with every tool imaginable. And he said, now will you come and open up and show the jury what you mean on this brake? And he hung his head and said, I don't know how. So I don't need to tell you that that didn't go well for the plaintiff. So years later, I'm trying a bicycle case involving a brake. Yosemite Park, woman rode down a hill and the brakes didn't work on her rented bike and she crashed into a tree and head first broke her neck, paralyzed for life from the neck down. And I began to think when I saw the defense lawyer in a deposition, he brought in a bike brake and he was swinging around in the depot, and the light bulb went off about this story I had been told. And so I called up my brake expert, little guy who worked down the street from my house, been doing it for 10 years. I said, I'm going to send you an exemplar and I want you to be able to take this thing apart in your sleep. He said, okay, Mary. So I sent it to him. Day before I put him on the stand, I called him up. I said, you know how to do this, right? And he said, oh yeah, I'm ready. So I put him on the stand. He gave his testimony. To my surprise, there's a table in front of him with a white piece of paper. And the defense lawyer asked him to come down and open up this brake that he had, a bicycle brake exemplar. And he came down and he went, chick, 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 opened it up. I was so proud. So that war story really did make a difference in the case. Who knows, maybe that war story will help you someday on a case. But when you go to seminars and you listen to people who tell the stories of their cases, they can help you, and you can see how they can apply to what you're doing and your story or your case, and how that can help you in the future.
Thank you, Mary. All right, Larry Grassini.
Well, thanks, Stacie. To follow up a little bit on what Bruce said, I think early on, a matter of fact, right away in my trials, I learned you've got to be yourself. I mean, you can't fool a jury. You're not going to be able to make them think you're anything other than yourself. And if you do try, you're probably gonna lose. You have to be authentic. And most of us on this panel were fortunate in that we didn't have much that we were able to do except be authentic, because we tried trials before we had much background in trying trials. I was a lawyer for 2 weeks, and I tried my first case, a jury trial, and I'd never been in a courtroom before, so I kind of had to be who I was, and I ended up being who I was, which was probably not very good, but it got me through the trial, and I won this little case. And the second point that I learned right then was that I came back, and my boss at that time said, "You won, huh?" And I said, "Yeah, I won." He actually handed me a cupcake with a candle in it. That's the and said, "Well, congratulations." He said, "Let me give you a little piece of advice, and I think this is great advice for all of us." He said, "You know, you may have won that case, but don't walk around saying, I won the case. It was me. I was such a good lawyer. I won that case." He said, "Because you probably had a pretty good judge, which I did, and you had a good client, which I did. And he said, and obviously you had a good jury because they went with you. And that's in most times what's going to get you through these trials, because if you say to yourself, I won that case because I'm such a good lawyer, I won that case. When you lose a case, to be consistent in life, you've got to say, well, I lost that case because I'm really not so good. So he said, what you want to do is to be consistent is take the wins and the losses, try not to have great big celebrations after the big wins, so you don't have the big depressions after the big losses. And at that stage, I said to myself, well, I better take that advice because I'm going to have a lot of losses, I think. So I'll just agree with that. So that's what I learned early on, and it held me in pretty good stead.
Great. Thank you, Larry. All right, Buddy, last but not least.
Okay, just to follow up, thank you, Stacie. And just to follow up with what Larry said, I think one of the worst things that can happen to you after trial is if you lose, they come up to you and they say to you, you're a great lawyer, but you had a bad case. Versus they come up to you after you've won, they said, oh, you had a great case. And that is, you have to be yourself, and you don't want to be caught being this, quote, great lawyer, because jurors are very suspicious of that. But I think the answer to the question is a thing I learned at a very young lawyer, and it helped me a lot, is to overcome my fears and overcome what I call the Vince Lombardi syndrome. And Vince Lombardi taught losing is a disgrace. It's a disgrace to yourself. It's a disgrace to your family. It's a disgrace to your community. It's just the worst thing that you as a human being can do is to lose. And as a result, people, at least in my generation, became very risk adverse, and they were afraid. They would settle. I think the point being is if you don't enter the game and you don't get up the bat, you can never hit the ball, and you can never win. So you have to take that risk that, gee, I might lose. But that's part of what we do. And frankly, if you show me a good loser, I'll show you a loser. I'm not a good loser. I think I hate losing worse than I love winning. But it's just one of those fears that you have to overcome. And I see that so many lawyers these days are so risk adverse that they will settle to do anything they can to avoid having to enter the pit and perform in front of the 12. And that's a fear that I think that people have to overcome. Hey, each of us had to start with these fears and these misgivings as young lawyers. And we had to get in there and do it and take the risk and overcome these fears. But fear is a constant companion when it comes to being a trial lawyer, and you just have to come to grips with it. We did it. You can do it. And the only way you can find out about doing it is to do it.
All right, thank you. And thank you all for your responses. I think, Buddy, that's a perfect transition into the next question I wanted to ask you all in a roundtable discussion, which is settlement. So many cases are settling. Roughly 95% of all cases settle. So it's important that attorneys posture their cases for settlement. What advice can you give us for optimizing your outcomes at mediation? And let's start with you, Buddy, and then open it all up.
Well, from my point of view, the best thing to do to maximize the possibility of settlement is to assume the case is not going to settle, and that you prepare it for trial as if the case is not going to settle. And if it happens to settle, fine. But if it doesn't, you're ready. But it has two salient features. If the other side knows that you can try a lawsuit, B, you fight it in such a way that you're ready to go, and they know that you will try it. That really, in my view, maximizes the possibility of that case settling.
I agree. Anyone else want to jump in on this?
Yeah, I totally agree that a reputation for trying cases is a huge lever in settlement discussions. The insurance companies know who tries cases and who doesn't. They also know who the people are that try tough cases. So although you sometimes have a loss along the way because you're trying very difficult cases, that really stands you in good stead when it comes to settlement discussions, because they know you'll take them to the jury, even though you might lose the case, but then again, you might win the case. And so they've got to take that into consideration. My little piece of advice with regard to approaching mediation is really two things. Number one is patience. Be patient. Don't think you've got to rush this thing into a settlement. Take your time, keep your cool, stay calm, and you can gradually get the job done. The second thing is to be aware that every word you say, everything that comes out of your mouth is going to be interpreted and reinterpreted by the other side. We do that ourselves all the time, don't we? Well, I saw, a wink in the eye of the adjuster as the adjuster walked down the hall to go down to the bathroom, and I'm going to interpret that as being X, Y, or Z. We interpret everything. And when you have a world-class mediator like Stacie, she's watching every one of those little moves on both sides. She's picking up cues and signals from both sides and trying to figure out where the Venn diagram comes together to produce a settlement. So be very careful what you say. Don't be throwing out numbers, whether it's at mediation or some conversation before you ever get to a mediation with the other side, because that number is going to go into an adjuster's file and it's going to sit there forever. And by the way, one last thing, think once, think twice, think 3 times before issuing a 998. There are lots of ramifications for settlement purposes because it will be interpreted as a demand and they'll try to negotiate it down from there. So think carefully about 998s. It can really get in your way if it's not handled the right way.
I want to follow up on that. It was such a good point about watching people, and people are also watching your client. And a tip is to make sure you teach your client not to react to things if they're going to be there. And sometimes they have to be. I'm sitting in a mediation with a federal judge and magistrate and having warned my client not to react. And the judge says, well, $250,000 will really change your life. And my client's going, so we had trouble settling it for more than $250,000 at that point. So, but my point is to work your case up early, well before the mediation, and to send out your mediation brief early. And we hear that, but it really is true. And what's the reason? The insurance companies have to run it up the flagpole and committee it and roundtable it. And they want to talk to their experts. So as hard as sometimes it is to get the brief out well written and with all the attachments to help them to see how good your case is.
Great, I agree.
And I think that on that point, you've got to give the mediator as much as you can to help them help you if you really want to try and settle a case. And so your mediation briefs ought to be as extensive as, without forcing them to read too much, but any type of little video clips that you want to put, day in the life film, I think all of that is very helpful. And frankly, I don't quite understand doing a mediation brief and then not giving it to the other side. I mean, if you really want to try to settle a case, I mean, I agree, you gotta be ready to try it. But if you're going to go to a mediation and put all the work into a mediation brief to give to the mediator to help the mediator, it doesn't help the mediator if the other side hasn't seen all your good work. So I would say give the mediator all the help he or she needs, and give it to the other side too.
Yeah, on mediation, I think we have to remember that a mediator is really not concerned with truth, justice, and the American way. The mediator's role is not to tell you you have a better case or that sort of thing. They're there to settle the case. And I think that you need to give the mediator ammunition to be your advocate when they go into the other side, to talk to them, to be persuasive. But I think one of the things is if you have to convince the mediator that you're not going to be the weak sister, that you are there to mediate the case, to get to a fair resolution. But if the case doesn't settle, you have to convince the mediator to convince the other side that you're prepared to go the route and try that case. Because I think in terms of maximizing recovery is if you come off as being the weaker one, then you're the one that's going to get picked off in the mediation.
I would just like to add that I think there's two important things. One is to be ready for trial. And the defense knows when you're ready and you're not ready. And the mediator knows when you're ready or you're not ready. And the thing that scares defendants more than anything is a lawyer who's ready to try the lawsuit if they don't get a settlement that they can accept. The mediator's job is totally different. Their job is to convince you and the other side to find the number that you both can agree to. And probably if it's a big case, most defense lawyers and the plaintiff's lawyers all know that number someplace within 10 or 20% of one another. They're going to get to a number. So you have to use the mediator as an ally to try to get someone who, A, the defense listens to. So my advice really is to make sure you get a mediator that's not just all plaintiff and they're going to disregard that mediator because it's just the plaintiff's judge, a plaintiff's mediator, but to get someone who they respect also, who has some experience with them, because it's always going to come down to the mediator coming up with some number that everybody can live with, and you have to work the mediator like you're working the defense lawyers to make sure that there's no money left on the table. If I think it's what mediator says it's worth, if they can settle it for $100, they're going to settle it for $100. If they can settle it for $100,000, they're going to settle it for $100,000. You're the lawyer in this mix, and you have to use all these tools to try to get to the number. The case will settle if, in fact, you're ready for trial. The mediator will get you to the promised land, but you have to make sure that you don't. If you say, I'll take $1, they're not going to pay you $2. If you say, I'll take $1, they know you're going to take something less than $1. As a young lawyer, I once said to a defense lawyer who I had a lot of respect for, I will not take a dime less, and I forget what the number was, but whatever the number was, I will not, and we were actually picking a jury at the time. And he said, Larry, give me the number. Don't give me a speech that this is your bottom line, because you don't know your bottom line until that jury buzzes twice and you hear the verdict. So don't tell me it's your bottom line. I know you'll take something less. So you ought to think through that, what you're going to say and how you're going to say it, to keep negotiations going when you want it to go and have them continue, and also when you don't want any more discussion and you want this case resolved. And there's both those kind of situations come up all the time.
Well, on that bottom line situation, I just want to say one thing. When the defense lawyer comes to you and says, what I really want, if you just tell me the number that you'll take to settle this case, I just need to know that number. And I always say to them, no, you don't want to know that number, because if you know that number, then you're going to go tell the adjuster. And the adjuster is going to say, that's really not his number, because they know that that's not the way the game is played. So they're going to say, nope, that's not his number. And you're never even going to get the number that I'm going to tell you. So I'm never going to give you my bottom number.
Right. Well, as a mediator, I appreciate all this advice. I think it's spot on. So thank you for that. I'm going to switch topics a little bit right now. And our next question will be, you are known for being incredible trial attorneys. I know that we can learn a great deal from you regarding trial tactics, from picking a jury to persuading a jury to deliver a verdict in your favor. Each of you, I know, could probably spend hours on this topic alone, but briefly, what do you think trial attorneys should do to maximize their outcomes at trial? And let's start with you, Larry Grassini.
Okay. Well, I think one of the most important aspects of the trial, besides picking the jury, I mean, let's face it, if you don't get the right jury, it doesn't make any difference how good your case is. You're not going to be able to do it. So there's a lot of things about picking the jury and how you do that are important. But once you've got your jury on your opening statement, I think that it's very important. And there's a couple of principles that I have. Number one is it shouldn't be too long. I've never given an opening statement, even for the most complex of cases, that's been more than a half hour. And it should be always given without any notes. You've got to be able to give it in a way that the jury believes that you know your case and that you believe your case. And it's got to be given in such a way that the jury says, well, this fellow really does believe what he's saying. And finally, while everybody says it's an opening statement and it can't be an argument, and it shouldn't be an argument, you've got to try and figure out the closest way you can be to giving an argument without calling it an argument. And a lot of times, if you just throw in every once in a while, the facts will be, you keep a judge happy enough with your opening argument. But I just think it's, in terms of the trial, you've really got to have that your opening statement down, and it's got to be a story, because that's the first time the jury really gets a chance to hear what the case is about and who you are, and you don't want to oversell it. And you want to bring out in your opening any bad facts before they get a chance to bring them out.
For me,
let's talk about your first point, which was sorry, buddy, about picking the jury.
ladies
That
first.
you really have a lot of work to do beforehand, and that means that these days most judges like questionnaires, and so to work on the questionnaire to make sure that it has everything in there that you really need to know, and to give you a head start with them, to work with a jury consultant if you can, if it's a big enough case, to help you determine what kind of juror you want, and then to help you look at those questionnaires when they're done, and to help you deselect the jury, and which these days seems to be more getting the worst jurors off. And in the old days, we used to talk about voir dire to try to get the jury onto your side. Of course, you'd like to do that if you can, but we want to find the jurors that really can get off for cause, or there may be some other reason that you want to strike them. But jury selection is so important in this day and age, and it is really my recommendation, if you can, to work with a jury consultant to help you do that.
Yeah, from my point of view, and I think the OJ case really proves it. That case was in trial for weeks and weeks and weeks. That jury was out 25 minutes. because that case was over at the end of jury selection. That was it. The rest of it was just irrelevant show. That case was signed, sealed, and delivered when they say, I accept this jury panel as presently constituted. That's it. And so I think, that just to amplify whatever everybody else has been saying is voir dire. In the old days, we used to think that in a few moments of eloquence, we could overcome a lifetime of attitudes with jurors. It doesn't work that way. I think the whole goal in voir dire is to figure out who the evildoers are, who the baddies are, who the monsters are in that panel for you. And it's all that nonverbal communication, all those skills that you learn as communication skills you learn as one human being to another, observing them, seeing how they react to you, see how they react to the situation. And I want as many eyes and ears in that courtroom during the jury selection as I can muster. Jury consultants, but they're not a panacea. So there's a lot of black magic when it comes to picking a jury, but I just can't overemphasize how important these days picking a jury is. So that's my 2 cents as to what I think is become the preeminent issue in trying case these days.
I would like to focus. Obviously, picking a jury is very important, and what they say or don't say is very important. And I've always said this, I'd never pick a male juror who dyed his hair, because if he had one of these jet black hairs, not that I'm jealous that he has hair.
Yeah, look at Larry, look at us. Huh?
Something that most of us on the panel have in common.
Bruce.
Yeah, and Mary, of course. But they're not being honest. They're not. One thing if they're an actor, but assuming they're not, the fact that they would put black polish on their hair to make them look something that they're not is a juror I don't want. But I want to just jump ahead a second. What I think is so important, which has sort of been touched on, is you need to keep this case simple. I've tried the most complicated products liability cases, and on automobiles, and I don't know the first thing about an automobile. I don't know what makes them run, except that you need gas and oil, but I don't know where it goes or how it goes. But I always used to think that if I can understand this engineering point, let's just say like in a park reverse case or in a that type of thing, if I can understand it, then I can tell the jury in the simplest of terms and do the simplest of things during the preparation of that case and the trial of that case that will illustrate that. For example, in a park reverse case in Ford Motor Company, when there used to be these cases, had engineers galore that were studying this and all these technicalities, why the lever couldn't get out of park and get into reverse. But if you did a video, which I did in those days, and showed that the person can't be hurt unless this phenomena occurs, it goes a long way to convince jurors that they don't have to be an engineer. They can just see how you can't get hurt. It wouldn't happen but for this kind of demonstration that you can do. So there's a lot of ways to skin a cat, and you have to make it simple. If it takes engineers to understand your point, in a products case, for example, you're not going to win that product. You're not going to win that case. But if a lay person can understand why this thing needs a guard, or why this needs a shield, or why this has to be designed in a fail-safe way, if that's something a lay person can understand, you can win that case no matter how many engineers and how many experts are against you. So keep it simple. so that they fit. It goes back to making the case fit within the instructions. Does the product meet consumer expectations or whatever the instruction might be? Handle the whole case that way, and you're going to get a successful outcome in the end of the day. But if you make it complex, if you fall into the defense scheme to make this case complex, you are going to find you're going to lose that case, because your job is to keep your case safe, in that you build a wall around it that defense can't penetrate. And if the defense can get a hole in the brick and the whole thing comes down, you're going to lose. But if you keep it simple and keep it tight, you eliminate the places that the defense can come at you at.
I cannot believe the number of things that are being said by my esteemed colleagues here that I have thought myself over the years, virtually in the same terms as they're being said here today. And we've never even talked about these things. So I want to add one little thing about a trial. I once heard somebody say years ago that a trial is nothing but a fight for credibility. You know, there's more to it than that, because you've got to get a jury, especially these days, that is open to hearing what you have to say. Just open to it, not necessarily lined up on your side from day one, but just open-minded enough to listen to your case. If you think about our current situation politically, there are certain percentages at the ends of the political spectrum that are closed to listening to the evidence about anything. They've made up their minds. Don't bother me with the facts. I have my point of view and I'm going to stick there. You want to get rid of those jurors if you possibly can. Both sides do. But when you get a group that's open to hearing what you have to say, then a trial is nothing but a fight for credibility. So much so that years ago, I had a case where the lawyer on the other side, the last name of that lawyer was Justice. And so I started thinking, wow, every time the judge says, would you like to ask questions? The jury's going to hear this person described as, I mean, I actually toyed with the idea of changing my last name to Credibility. So it would be Mr. Credibility against, you know. So I didn't change my name. I kept it where it is. But I recall when I was a brand new lawyer and I started out as a defense lawyer, I remember one of the partners from the firm was Lee Wenzel. It was the firm of Morgan, Wenzel, and McNicholas. And they used to say of Lee Wenzel that he had a face like an affidavit. And that's the highest compliment you can give to a lawyer that tries cases, because if they have credibility with the jury, that gives them a huge leg up. So fight for credibility.
All right, thank you all so much. I want to introduce another topic for you, and it's as follows. You've been practicing law for quite some time. What are the biggest changes you've noticed in the field of law today? In answering this, please feel free also to touch on how your trial strategy has changed since the pandemic. All right, Mary, you want to get us started?
Two things. First of all, there are a lot more women, which is, I think, is a great thing. I used to be the only woman in the room, and I would show up for trial call and the courtroom was filled with dark suits, but it has really changed. And of course, I think it's wonderful for the bar. I think it's wonderful for the public to have women's perspective. The second thing is email. And, you know, when I first started practicing, I had to learn how to dictate, and then the secretary would type it up. And so those days are gone, but we really are, and the pandemic's only made it more so, is that we're practicing law by email, by computer, and there are a lot of good things about it. certainly serving things by email. But I think it really is a huge change for the practice, and it means that we have to, maybe you used to dictate a letter and then the secretary typed it up and she brought it back, and do you really want to send this with all of these bad words in the letter, that kind of thing. And now we hit send really fast, but we need to be clear that and keeping our civility with email, but it also has made things faster and I think better overall for the law, and certainly serving things to the court by email and not having to copy and send off huge oppositions to motions for summary judgment has been a really great thing.
You know, for me, I come from the days, the dark ages, where we had manual typewriters and 5 carbon paper copies. And IBM came out with this selectric typewriter that would erase the space before. And I said, my God, that is going to revolutionize the practice of law, this IBM that can erase. And I think the biggest change for me is the technology. But because of the technology, the same 3 or 4 day case in the old days to try is now 3 or 4 weeks with boxes and boxes and boxes of paper because of the computerization of technology. The case hasn't changed that much. The facts haven't changed that much, but technology has given us the ability to sort of launch unbelievable amounts of paper at each other by push of a button. So, you know, the technology is the good with the bad. But the other thing that I think is the biggest change for me is the Friday night massacre. And what do I mean by that? Before the 1980s, there was no such thing as summary judgment. Then the California Supreme Court changed the rules with regard to the burdens and summary judgment. I was admitted, I think I have the lowest bar number here. I was admitted in January of '68, and there was no such thing as summary judgment for the first 20 or 30 years I practiced law. And then all of a sudden they changed this burden, and every Friday night at 5 o'clock, there would be a big stack of paper, summary judgment. You had 14 days in which to answer the damn thing. And then, with the help of people like Bruce and some others and CTLA, we were able to get a bill through that at least made 75 days notice on summary judgments. But to me, it is one of the most god-awful burdens that I wish we could go back to the good old days before these summary judgments. They just make me nuts. And so that's my editorial perversion for the day.
I think, when we first start trying cases, they were fact-based, who hit who, what did you slip on, that kind of a thing. And now the cases that seem to get tried, you want to try, they're more morality plays. It's more about bad actors, or bad drugs, or bad doctors, or bad products. But you can get deeper into the facts behind the product and maybe show that the reason the product is bad is because the manufacturer was trying to save some money or something like that. And those are the types of cases that seem to have the best outcomes. I think you need to try to find some way, if you're on the plaintiff side, to, first of all, the jury's got to like your plaintiff, but it helps if they don't like the defendant, especially if it was something for the reason that the defendant did something that they knew might cause a problem and they still did it. That's the biggest, besides the fact that as someone said, the cases used to be tried in a week, and now it's months to try these cases. They used to be able to try them for $5,000, and I don't even want to talk about what it costs to try some of these cases. Now the products
Yeah,
can't wish.
it is a different world now. When I first started practicing, you'd answer ready for trial. You'd have your briefcase with your exhibits. You'd have your blow-ups on foam board, and you'd go down there. You were ready to try the case. You were assigned to a judge, and you try the case. It wasn't the endless paperwork leading up to the trial with binders of everything on and on and on. And you know, you'd go down with your motions in limine on the first day of trial because the judge had never seen the case before. You go in, you have your pretrial conference with the judge right there, decide, you know, whether to call up a jury that day, the next day, or whatever, and you try your case. Now it takes a lot more pretrial activity to get the case in position where they will actually assign you to trial. There are some benefits to that. There are some downsides. But the ability to try, I mean, I remember a year where I tried 7 cases in a year. I think that year, Larry Grassini tried 16, if I recall that number correctly, Larry.
Right.
These days, to try that many cases in a year, to try 3, 4, 5 cases in a year is a bit of a challenge if you're doing anything significant. So those are big challenges. But let me talk for a second about the summary judgment thing. I remember the days when we never saw summary judgment motions on complex cases, and then summary judgment became the vogue. And the problem was you only had 14 days to respond. So you couldn't do any discovery. You just had to hope you had things together enough to file an opposition within 14 days that got you over the hump. What happened when the change was made to 75 days notice is it gave you 61 days before you had to file your opposition. That was enough time to serve a couple of sets of interrogatories, to take depositions, to serve requests for admissions. And all of a sudden, oppositions to summary judgment became much more massive and much more complete. And in a sense, when the defense files a motion for summary judgment now, they're alerting the plaintiff's lawyer to what the issues are. And if the plaintiff lawyer hasn't adequately prepared on those issues that the defense wants to knock the case out on, the plaintiff lawyer has time to do something about it and get their act together. So I think it's a mixed bag. I don't like endless summary judgments. On the other hand, they're showing their cards. They might have been better off waiting and doing it as a non-suit motion at trial. So it's a mixed bag. I'm glad we have 75 days notice now and not the old 14, which was impossible.
Also, what's changed dramatically is the time that it takes to handle a case. In the olden days, we all used to go down and we'd try a case, and there'd be interrogatories and a few depositions, and there'd be a doctor and sometimes an economist. Today, everything is experts. I mean, the defense has experts on every possible subject in your case, and you then have to get experts in every possible subject on your case. So it becomes very expensive to handle these cases. And where a sole practitioner could have survived in the 70s and 80s, today you need a whole support staff behind you to deal with the amount of paperwork, to deal with responding to experts and what's going to be said. And judges are different today because the judge you get today has the case from the start. So they have their rules and you're stuck with their rules, and their rules require all this paperwork and everything to be done in binders for the jury and binders for the defense and binders for you, and a staff of people to work the exhibits so that you can get them on a screen. Things like that, that really take a lot of money and a lot of man or person power, I guess, to put on a full-fledged trial. So where we were trying cases in the olden days, you know, over $2,500 difference in a case value from the defense to you, today you can't do that. You can't, the plaintiffs can't afford to fight a case and spend all this money over $2,500, even though justice may say you should do it. There's this practical side that really becomes a major problem in these cases.
Thank you. So we only have a few minutes left. I was wondering if you've noticed that the pandemic has changed anything with regard to either your trial strategy or maybe to your settlement, how you value settlement. Does anyone want to speak to that for the few minutes that we have left? Yeah.
Since we only have a few minutes, I just want to say that through the trial organizations, I was educated, and I consider all these people my friends, my good friends that I've met through the trial lawyer organizations. And it warms my heart to see these people and to be able to participate with these wonderful human beings after all these years. And I think it's a tribute to the collegiality of the profession, in which we are also proud to be members. Not the subject, but I just wanted to get it in.
That's very sweet. Thank you.
Well said. Yeah.
All right. Well, we only have a
I
few.
could remember who you guys were.
You know, Stacie, I just want to, I wanted to say one little thing, and that is that for all the younger lawyers that are out there watching this, make sure you balance your professional and your family or your personal life. Sometimes, especially when you first start out, it just seems like all you want to do is get in there and get that case tried and stuff. And it's important that you realize that you've got to have a balance in life. It can't all be just the law. You got to have a personal and a family life that for both yourself and the people around you. And I'll just tell this story that there was a defense lawyer, and he was a good defense lawyer, tried a lot of cases, and I saw him one day and I said, well, how are you doing? He said, well, you know, I realized, I said, I've got 2 daughters. He says, and I realized I really didn't see my first daughter grow up at all, because I was in trial, I was incident ready all the time. I was down here trying cases, and I decided to change my ways, and I'm gonna change. I'm gonna spend more time with my family. I'm gonna spend more time with my kids and on other matters. And I said, well, that's great. That's terrific. I'm glad to hear that. And I went on my way. And a month later, this is a true story. A month later, I read he had a heart attack, died on the courthouse steps. And I thought to myself, you know, that poor fella never got a chance to do what he wanted to do. So I sound like a preacher here, but I just think it's a great idea to remember when you're a brand new lawyer that there are things other than trying a case and winning a case. And a sermon.
That's very well said. To give a short answer to your question about mediation and COVID, I think that Zoom mediations have actually worked out pretty well. I mean, not always, but one of the reasons is that it's easier to schedule them. You don't have to worry about, number one, the insurance carrier coming in from Hartford, Connecticut, which they won't do, but they have a little less excuse if you're gonna do it by Zoom. So I see more participation with the carriers. and perhaps other people too, other lawyers that, and so since people don't have to travel, it's easier to schedule them. You can get them sooner. And the other thing is that you don't have to worry about going down the hall to try to find the mediator. So I think that they tend to go faster too, maybe partially for that reason, but also I just heard in general that people at meetings that not just mediation, that people tend to get to the point, and so that makes them go faster perhaps.
Thank you. Any other closing remarks before we say goodbye today? And I appreciate everything you've all said.
You know, I have a little something, and it references back to something Larry Grassini said earlier about don't think that it was because of you that you necessarily won the case, or else you're going to have to accept that it was because of you that you lost the case. Certainly the lawyer has a huge influence. But what I've learned over the years is that you've got to have a case. There's got to be a basic set of facts that a jury will accept. And you can be totally silver-tongued and brilliant, but not get over on it. And you've got to forgive yourself when you lose and not overpraise yourself when you win. And so just one quick little story on that. We do a lot of focus groups in our cases. All the lawyers here do. And there was one years ago that was an impossible case factually. But I wanted to try to get it settled. It hadn't settled yet, so we did the focus group. And I had one of the young new lawyers in the firm at that time who had no experience doing any of this serve as the defense lawyer. So I got up and gave the most eloquent statement I could, my opening in the case in the focus group. And I just felt like I dazzled everybody, and here we go. And then the other lawyer got up and was totally tongue-tied. It was a disaster. He was nervous. He was scared. He didn't have a command of anything. He didn't know what he was doing. And I remember on this other side of the one-way mirror going to my jury consultant, we're going to have to do this again because this is not a good test. He's not putting up much of a defense. So they start to deliberate the focus group. And one of the women says, you know, that Mr. Broillet, he is really an articulate guy. Too bad he doesn't have a better case. And that told me everything I needed to know. So if you lose a tough case, you know, Teddy Roosevelt said it, far better it is to dare mighty deeds, though sometimes checkered with failure, than to live in that gray twilight populated by those poor souls who know neither victory nor defeat. So just do the case, have a short memory if you lose, and go on to the next cause that you have for somebody else. Okay?
Thank you all.
And thank you all. Thank you, panelists. Thank you, ADR Services, for hosting this. And thank you for joining us today. Have a great day, everybody.